Hey, good afternoon, everybody. So glad to have you join us. I am Neil Kalin. I am joined by Michael Simkin, excuse me, my co-host. And we have a wonderful guest today. We have Anna Liu, who is going to tell us a little bit about herself, her practice. She's going to chime in. She told us she was going to chime in on a couple of cases for which she has a lot of knowledge, and maybe we could coerce her into talking about the cases for which she has no knowledge, in which case that will be three of us talking about cases for which we have no knowledge. So we'll see what we can convince Anna to do as we get moving along. So again, welcome to October edition of What's Up with Us. What are we going to be doing today? Here's what we're going to be doing. Ooh, it's October, so it's a scary month. It's a nice month. We've got some great cases. Lynch versus Peter and Associates. Does a subcontractor have a negligence duty of care to the property owner? Alameda versus Sheehan. You know what? I didn't check this morning to see if the official site has been posted. Sorry about that, everybody. It wasn't when I first prepared our materials for today, but it had to do with a 3-day notice naming a corporation who was going to receive payment and whether the notice was sufficient to allow the eviction to go forward. Then we have our interview with Anna. We've got Simwellian, which is the non-compete in this partial sale of a business. And I thought, you know, that might be applicable to a lot of you real property practitioners because you may have set up organizations or entities to own property. I know it's a relevant issue in my business, which is I deal with real estate agents and a lot of brokers sell their businesses, but what if they maintain a partial ownership? So if you're in that line or that field, it may be of interest to you. And we're going to conclude our cases with San Francisco Apartment Association versus San Francisco, where the city and county of San Francisco wanted a 10-day cure period instead of the 3-day notice that you real property and eviction practitioners are all familiar with. So we'll see what happened with that. And we're going to end up talking about a few activities that we have coming up at the real property law section of the California Lawyers Association. So let us quickly get started. Hey, happy Halloween in advance, everybody. Glad to have you with us today. And Michael, you've got your usual smile on. Do you have any kind of October surprises for our listeners today?
Well, we might have some surprises for the November What's Up With Us, meaning we're going to start to have Simkin secrets. So I'm going to try to share some of my things that, like the unwritten ways to win cases, completely legal, completely lawful, nothing like, weird, but how you should approach cases or things that they don't teach you in law school, but in life. And I'm going to try to share some of those with you starting in November.
I like that, Simkin's secrets. I love that. I love that. So that's what they're gonna be known when somebody goes into court, whether they're in Southern California or Northern California, and they use those techniques. And we'll see. Maybe that's just going to be known statewide as a Simkin secret. I
No
love
more, no
that.
more Witkin says. It's going to be Simkin says.
Right. I like it a lot. That's going to be a great new addition to What's Up With Us. And as long as you're talking about that, I will mention that I don't know that we're going to start it in November, but we're going to start next year. You listeners, if you've been here before, you know that you get 1 hour of self-study MCLE credit. And we have explored, we found out that we can do some specialty credits through What's Up With Us. So we're going to start next year. We're not going to do that every month, but we're probably going to have a couple of months, maybe 3, where we allow you to get some of those hard to get specialty credits. So a lot to look forward to next year, a lot to look forward to today. We've got some great cases to discuss. So let's just jump right into it. And we'll start with Lynch versus Peter and Associates. We're talking here about a California appellate court case. I think all of our cases today are California appellate court cases. We've had some federal cases the last few months, but today we're focusing on California, and kind of an interesting situation here where Lynch is a property owner, a homeowner, hired a general contractor, wanted to do some substantial improvements to the residence. It was located in San Clemente, and the improvements totaled just under $400,000, right? At some point, Lynch was unhappy with the contractor, made some changes. The new contractor hired the defendant and an engineering firm for a whopping $360 to inspect a footing trench for the proposed addition to the property. The contractor had a term in its contract that says, hey, my liability is limited to twice the fee. So if I screw up, all you can get from me is $720 on your $400,000, remodeling or improvement work that you're having done. Defendant Peter and Associates prepared a one-page handwritten report that said the earth was geotechnically acceptable and suitable for its intended use. Lo and behold, why do we have a case? Because it was not, right? The improvement was built, the footing collapsed, the addition moved, extensive repair work was required. The homeowner filed suit, interestingly enough, against their original contractor and the subsequent contractor and the engineer, and named various causes of action, right? The defendant filed a motion for summary judgment on the negligence claim, saying, wait a minute, I had no privity of contract. My written contract was with the general contractor, not with the property owner. I don't know Lynch any duty of care for negligence. We don't have a contract at all. The trial court said, yeah, that's right. No privity, no duty. So Lynch appealed. The appellate court looked at the situation, and the appellate court said, yeah, you know what? We're going to find that there is a duty of care despite the lack of privity. And they said, you know what? We really need to look at sort of modern nuisance jurisprudence. And it's not privity that's the key issue. It's really the 5 factors in figuring out whether there's negligence, right? The most important factor, foreseeability. Of course, here there definitely was injury. Is there a connection between the activity and the injury? Well, it seems like that's not too high of a hurdle to reach in this case. What about moral blame and the issue of preventing further harm and finding whether there should be a duty at all? The court looked at construction claims, and we look at my interesting quote for the case. This case demonstrates the veracity of the California Supreme Court's observation that the declining significance of privity has found its way into construction law, right? So don't look for an easy way out, especially if you're dealing with construction law and even outside of construction law. Mike, does this case make sense to you?
Complete sense. I'm kind of like surprised that the trial judge messed it up. I mean, like you said, the factors of professional negligence, or even if you're not a professional and you do this intended beneficiary negligence, like that Biajanka case, that was like a law school case and like first year torts, right? So I don't know how the trial judge got it so wrong, but what I found fascinating about this case are things such as, like you mentioned, the contractors are $360. So there is some sympathy. This guy that's doing this inspection, sticking some pole into the dirt to see if it's compacted correctly, I guess, he got paid $360, and then him, or if he had an insurer, is involved in a lawsuit with tens of thousands of dollars, $100,000 or more in legal fees over 360 contract. But the court went through very clearly and talked about who was intended to benefit from this. Plus, there's facts. Always look at the facts. That's one of my practice pointers, right? The appellate opinion also pointed out that a copy of the one-page report got sent to the property owner. So clearly, the property owner was intended to benefit from this $360 contract. So the facts are very supportive. This issue, talking about nuisance, I never understood that. If I had a case like this, I wouldn't have pled nuisance. I mean, it's not a big deal, I guess, but it's professional negligence is what this case is. It's not nuisance because the guy didn't perform his services correctly.
So, Michael, but before we go on and, we'll see if we can cajole Anna to make some kind of comment here. But before we do that, I'm so happy to see in the Q&A tab that we have a couple of people that are paying attention today. So I'm so thrilled. And Christopher Fall was actually reading through as I was going through this slide. He goes, "Elements of nuisance. Is that a typo?" Yes, so I have to admit, sometimes when I'm going through these things, I say the wrong thing. It should be the element of whether negligence should be applied. So thank you, Christopher, for paying attention and noticing that in the appellate decision paragraph on your slide. The second line down said, the evidence contradict the elements of nuisance, and I should have said negligence. Should have written down negligence instead. So nice to see that we have some detailed oriented listeners to what's up with us. Glenn says, will the materials download? And so, Glenn, you're probably new to what's up with us. We're glad to have you. So probably tomorrow, Brooke will step in and correct me if I'm wrong. You'll receive a copy of the materials, and you will also receive some kind of statement giving you the 1 hour of MCLE self-study credit. So I don't think you could download direct from the webinar, but you will be sent a copy of this information. Very active today. I see we have somebody raising their hand. I don't think I could call on you. We haven't done that before in the session, Joanne. So if you would not mind, if you would put your comment or your question, and somebody else I see is raising their hand too, please put them into the Q&A tab so that we can read those and then address those. We're never going to get to move on here. So I see we have a great suggestion from Robert. I'm always asking people at the end of our What's Up With Us if you have any ideas or suggestions. And so Robert Sloat put one in talking about AB 2424. Yes, you are absolutely right. I was reading about this the other day, a major change in foreclosure law allowing additional time depending on whether property is listed or whether property is in escrow. So that's a great idea. Maybe we could do that for November, Michael, because it's leading up to the start of the new year. So that's a great suggestion. I haven't scrolled down in my Q&A tab. So let's see. Was there another limitation? Great. Thank you, Lynn. Was there a ruling on the limitation of liability clause in the contract? I'm not sure, but I don't think it's going to contractually apply to the negligence cause of action. Michael, do you remember whether the court specifically addressed that issue?
I don't think it did, but I do believe if you're not in privity with the contract for that, I don't think that's going to be a limit. They won't have that double the fee paid limitation for the third party intended beneficiary. But then I'll look real quick. I'll chime in maybe after we finish the next case.
I just took a quick search because I had the case. It looks like on page 4, the contract contained a clause limiting their liability to twice their fee. Their
Yeah,
fee
but the
is,
point is, did they discuss if that applies to people not in privity of the contract or the intended third party?
yeah, we'd have to go through it for that. But I mean, the fee is $360. It's not a big limitation.
Well, the court didn't think that that made a difference. They didn't like that was oh, back to like how you're supposed to do your legal work as a lawyer. When
Yeah.
the defense attorney was preparing their opposition to the summary judgment, he didn't have sufficient evidence to, to show that there was, to rebut a lot of this stuff. Like there's like a one line he said, "I only got paid $360." That's not going to work.
Right, right. I mean, that may, go to some kind of mitigating factor as to what the overall damages are, but that doesn't address the primary issue of liability. You say that, Michael, about presenting sufficient evidence. I had dinner last night with a friend. We were talking about an arbitration that I had recently completed as an arbitrator, and went through nearly 1,000 pages of documents that the two parties submitted. And guess what? The plaintiff did not bother to provide any evidence of their damages. So it's like all these great legal theories that were brought up, but you forgot the core element of bringing a claim, which is you have to prove your damages. And so, don't confuse me with, 1,000 pages. All you have to do is say, here's our contract. Here's how much we got. Here's how much we didn't get. Very simple. It would have been so easy to do something like that. You threw everything else in there. I'm not a litigator, but it seems to me that's something that anybody who litigates should know from day one of their practice.
I heard a judge once. I think he called it the Chick Hearn defense. So the Chick Hearn thing was like no harm, no foul. So
Okay.
that's like damages. You don't have any damages. That you're missing an element.
Yeah. So there we go. We got a little advanced taste, right, of a Simkin secret, which is make
No
sure
harm, no
you
foul.
make sure you proved your case, first of all, right? Prove your case before you go
But,
on to anything
but
else.
that's actually critical. I get phone calls from, potential clients and they say, yeah, they should have done that. Yeah, okay, so how did you lose? Like, what are you out of pocket? Oh, I had to spend the night at my friend's house. Okay, did that cost you anything? No. Well, how do I explain that to a judge how to quantify your damages when you are not out of pocket anything and you didn't, you can't do it.
All right. So there we go. So that's Lynch versus Peter and Associates. So thank you for joining us. So let's see. Okay, so Joanne, I see you there. I'm looking. I may have the ability to allow you to talk. So Joanne, Bernard, if you're still there, I'm going to click on something and we'll see if you have the ability to talk. Joanne, why don't you try to talk? We'll see if that works. So I'm going to ask you, you would have to unmute yourself. I don't have the ability to do that. Are either of you hearing Joanne? I'm not.
I'm here.
Oh, great. Thank you. Okay, Joanne. So you raised your hand. What did you want to ask or tell
No, I
us?
hit the wrong button.
Oh, okay. No problem. All
Sorry,
right.
sorry for all the confusion.
Hey, no problem at all. We're just glad that we have some listeners who are paying attention today. So thank you very much, Joanne. All right, I'm going to try and move us on to our next case. Here we go. City of Alameda versus Sheehan. So what do we have here? Okay, really another interesting case, and Michael practices a lot in the landlord-tenant area, and so does Anna. So you two are going to save me the embarrassment of talking about something that I know nothing about. So I really appreciate having the two of you on with us today. So what do we have here? Sheehan, a residential tenant in property that was actually owned by the city of Alameda, right? So you get all these cities and then pass all these laws. Now, this isn't one of these cases, but it's always interesting when, cities pass laws and then they turn around and come back to them, although that's not exactly what happened here, but I always find that interesting. How the city of Alameda is owning this residential property, I don't know. So the tenant stopped paying rent in December of 2020. And then what happened a year and a half later, Alameda served the tenant with a 3-day notice to pay rent or quit. The notice stated payment is to be delivered to, and look at the language in quotes, City of Alameda, care of River Rock Real Estate Group, and the address was included. Tenant did not pay rent, did not vacate. The city started an unlawful detainer. The tenant moved for judgment on the pleading saying, wait a minute, the notice did not name a natural person to whom rent should be paid. Alameda said, you don't need a natural person. All you need is a person. Person includes entities for purposes of the unlawful detainer law. The trial court said, well, no, the UD statutes require that you identify a natural person, enter judgment against the city. The city appealed. The appellate court looked really at two primary issues. They said, let's look at CCP 1162-2. I always think it's kind of weird the way that statute reads, right? They don't go into like A and then 1 and then 2. It's like 1162-2, right? That says a 3-day notice must include the name, number, and address of the person to whom rent payment shall be made. The court looked outside of 1162 and says, well, if we look elsewhere in the CCP, Section 17 defines persons to include corporations. We have no reason to believe that the rule should be any different for purposes of an unlawful detainer. So basically, trial court, you got that wrong, but the appellate court went on to say, but how about naming the person, right? So naming the entity, right? What would satisfy 1162-2? And the tenant said, obviously the tenant, in my view, did not do this before they stopped paying rent, and they never paid rent, and they never offered to pay rent, right? But they said, well, the Secretary of State has no listing for River Space, Rock Space, Real Space Estate, Space Group. So how would I know who to submit my rent to? So of course, that's the real reason I did not pay rent for a year and a half, because I had no idea. Rather than submitting a payment to River Rock Real Estate Group at the address, instead of doing that, what was the first thing I would do? I would go into the Secretary of State's website and see if there really is a River Rock Real Estate Group. And lo and behold, there is no River Rock Real Estate Group spelled that way, right? There is a River Rock spelled with no space in between river and rock, and also is Inc. Well, there's no Inc. in the notice to pay rent or quit. So the appellate court, I thought, really just gave something to the tenant, right? Says, well, that's just too confusing. You wouldn't know what to do in a situation like this with the way that the entity was named. Therefore, the statute was not strictly complied with. You've got strict compliance with certain aspects of the UD law, and maybe all aspects of the UD law. That's something for Michael and Anna to chime in about. And therefore, they affirmed the judgment for the tenant and against the city of Alameda. Can't wait to hear. I thought it was just farcical, quite honestly, that second reasoning. But I'd like to hear from the real experts in landlord-tenant law.
Well, this has not been a new issue, okay, about naming a person. I think that it's been at least 10 years that they have this put the name of the person who received the rent issue. And in Southern California and Los Angeles, tenants have been successful to win cases where the landlord didn't put the name of the person, including if it's a corporate entity. I've always said, pay the rent to ABC company by paying Susan located at whatever between these hours. Um, Anna, have you guys been using that defense for a while?
I totally agree with you. The UD rules are so strict. They're so harsh. You miss one comma in your notice, you don't have the correct name, or you're missing, an hour that you can pay rent, and your case gets tossed and you have to start all over again. So yes, this comes up for us in our practice where we are representing, for example, John Smith, trustee of the John Smith Trust. And we list on our notice, pay rent to John Smith, trustee of the John Smith Trust. But John will ask us, hey, can you list me as an individual? I don't want the rent to go to my trust. And I always have to tell them I got to be consistent with the ownership of the property and list you consistently in the notice. And then the Sheehan case confirms that, because if you've got a couple of different names in the body of your 3-day notice to pay rent or quit, courts like this can easily toss that case out. You got to start all over again and serve a brand new notice. So these rules are very unforgiving.
Anna, that's
So
interesting. Are you saying that person must be, as the court said, like what is a person, singular and not plural? You couldn't say it's a corporation, say pay Joe or Sam of X corporations. Can you put more than one name?
Yeah, we've put more than one name. We've done it the same way you have, ABC Corp, care of Susan. But the point I think here is making sure you're consistent throughout your notice and making sure your ownership matches. And in this case, with the property manager group, if you're inconsistent with the California Secretary of State and how that company is registered, you got to check that too. So there's multiple layers of checks that need to be made. I think the court got it right that the person includes a corporation. I think that's very clear. And I agree with some of the comments in the chat box, the actual holding of the case, how the city or the landlord lost simply on that River Rock real estate group, and River Rock being one word or two words. Is that really ambiguous? Is that really why the tenant didn't pay rent?
So Michael, before you go on, there were a few comments. I just want to at least bring them to everyone's attention in case people are not looking at the Q&A tab. And it was mentioned here, I think, a couple times. Who was the tenant paying rent to before? Like, why was it all of a sudden such a surprise that River Rock had to have no space in between? Where they were paying rent at some time, right before 2020. And I want to thank whoever put it in the comment, which was, how quickly we forget. 2020 was during COVID, right? So there was a lot of tenants who weren't paying rent for an extended period of time. It was very difficult to do anything about that. And in this case, again, the city waited a full year and a half before bringing the UD. But maybe that is a little more understandable thinking back to what was going on during 2020, the end of 2020 and all of 2021. So thank you for reminding us of that horrible period of time that we all lived through, just a few short years ago. And obviously, I've tried to block that out of my memory, so I forgot all about that. So thank you for bringing that up. And what else did we have here? Just another comment, Glenn, that Alameda and Los Angeles are two of the most difficult counties within which to bring an unlawful detainer. Okay. And let's see, Gilbert. What does Gilbert say here? If ABC Inc. is the landlord, should the 3 days say pay? I can't quite understand what else is being said, Gilbert. Maybe if one of the two of you, Anna or Michael, if you scroll down to the bottom of the Q&A, maybe you have a
I think it's asking
better
about paying
understanding
by a
of,
bank check.
okay. But who would you write out that bank check to?
That's a good question. I think you have to pay it to the corporate entity, not to Susan for the corporate entity. Otherwise, the bank's not going to accept it. But the point of the statute is who to deliver the rent to. It's all about delivering of the payment, not what's on the check.
Mhm.
Right,
I agree.
Anna?
I agree with you. And the statute's so specific. 1161 subsection 2 says you need to name like the amount due, the name, the telephone number, the address of the person to whom the rent shall be made. You got to have every single point in there, otherwise your notice is bad.
Well, I remember at one point in time, CAR, who I worked for, we had to add multiple lines to our form to include all of those terms. Now, how somebody fills it in, that's their issue, not our issue as the creator of a document. But yes, I remember we were thinking, it's so hard. All these documents, all these forms are getting longer and longer and longer. And a lot of that has to do with statutory requirements that are making additional impositions on the parties in a landlord-tenant relationship.
Oh, and Neil, this one, unless you mentioned it, did you mention about the typo on your slide? You already did that, right? The 1161, not 1162 typo?
Oh, no, I did not mention that. So thank you. I missed that one.
Okay.
Not a good month for me here at Woo making mistakes. So I apologize for that. Okay. All right, so I guess I just need to move on to November. But before we do that, Anna, why don't you tell us a little bit about yourself, your practice, what brings you to RPLS, what excites you about the law? Just kind of open-ended here.
Thanks, Neil and Michael. Hi, everyone. I am a partner at Steven MacDonald and Partners in the San Francisco Bay Area, is where I generally practice throughout most of the counties and cities up here. My practice primarily revolves around real property disputes, so specifically landlord-tenant, co-owner disputes, buyer-seller disputes, family property disputes, all kinds of cases in those areas. I've been practicing about 13 years, primarily in this area. So I am all about all things real property, love to chat about it, read the cases, and really dive into it. My law firm and I did handle a lot of landlord-tenant cases throughout the pandemic and of course before, and saw a lot of the issues that we talked about in the last case and in the case that we'll talk about in two cases, and really how those come into play in real life when you are both practicing in this area but also helping clients, family, friends who are either property owners themselves or tenants, and how to navigate the constantly changing laws in this arena. I will say that the laws have changed so much in the last 4 or 5 years, and keeping up with it is almost like a throwback to law school, where you are constantly having to read up on the cases, read up on the statutes, what's different, something that you might have done years ago may completely be different. So that's been an interesting and exciting challenge that we've been facing. What else can I share? We represent both landlords and tenants in our real estate cases. So we're one of the firms in the Bay Area that help both sides. A lot of firms are one side or the other. And so I find that I like that aspect of practice. For me personally, my practice primarily revolves around representing property owners, although I have helped a number of tenants, commercial and residential. San Francisco is also a unique city and county where we have the right to free counsel when you are a tenant in a residential eviction. So similar to, the right to being defended in a criminal case, we've got that here in the city. So every single residential tenant, regardless of their means, their income, they have the right to a free tenant lawyer to represent them in eviction cases. And so that alone makes San Francisco UDs a whole new ballgame, because you can bet that in almost every residential eviction in the city of San Francisco, that tenant will lawyer up with one of the nonprofits or free tenant lawyers, and that's the right to counsel, Prop F. It was passed by voters, I think, about 8 years ago or so. So that's also
So
changed
Anna,
the
I
ballpark.
got a quick
Yeah.
question about that. Is that
Yeah.
like a public, is there like a public, the equivalent of a public defender's office in San Francisco for tenants?
Essentially, yes, it's the Eviction Defense Collaborative or EDC. They primarily run the program, and then there are other nonprofits throughout the city, Tenderloin Housing Clinic, Justice and Diversity Center, all kinds of different nonprofits who will handle those cases. But that's essentially exactly it. It's like a almost like a public defender program.
Okay, sorry to cut you off, Anna. Go ahead.
Oh,
Go back.
no, that's it. I'm happy to, answer any questions. And not only do we practice landlord tenant, but also a lot of, like I said, co-owner disputes or buyer-seller disputes, non-disclosure cases. And particularly in the last few months, I've had a lot of family disputes where adult children inherit property from their parents who have passed away. Perhaps one adult child lives in the property and the other siblings don't, and they can't agree on whether to keep the property or sell it. And is the person living there, paying rent or not? Is that fair? So I have a lot of those cases. And next month, which Neil will sneak peek for us, I will be doing a program with another trust and estates practitioner on that basic fact pattern, what happens when there are occupants of property and the family members or co-owners don't agree on what to do with it. So we'll have a program on that next month.
So Anna and I know from real estate agents that happens all the time, right? They want to sell a property and, there was a death or some kind of transfer and somebody's there who maybe shouldn't be there or thinks they have a right to be there and creates all sorts of problems. I understand that. I'm going to have you give a super early sneak preview, though, on something completely different. We did not even talk about this, but Brooke, our coordinator for the real property law section, kind of reminded me of this when we were talking before the webinar, just a few minutes before the webinar, that Anna, first of all, you are an advisor in the real property law section, and you sit or you serve on the committee that is helping to prepare the retreat or the big annual meeting for the real property section next year. Is there anything you could do to kind of tease our listeners about what's going to happen next year?
Yes, thank you for mentioning that. I'm super excited that our annual spring retreat or conference that we throw as a section every year will be held in 2025 from March 6th through March 9th. And we will be in Monterey. So there will be very exciting activities to come with that. We have a really awesome panel of classes and MCLE courses that we've got lined up. We do this in conjunction with the Women in Leasing group, and they're in their 10th year anniversary of these conferences. So it's a big year. We're really excited about it. Last year we were in Palm Springs for the conference, so this year up in NorCal. And it's just going to be a really great conference full of networking opportunities in person and really great MCLE courses.
Yeah, I've been to so many of them over the last 10 years, and A, they're fun, and B, they're educational. Just one more time with the dates, just in case somebody's thinking of that. Yeah, I could go to Monterey, in the spring of 2025. What are the dates again?
Yes, March 6th through March 9th, 2025. March 6th through 9.
Okay, great. Thank you, Anna. Michael, anything else from Anna before we move on? Because I know both of you are going to have some things to say about our next cases.
Well, what Anna mentioned about when you have the practice involving, trust and you have real property, you have to sell it and doing evictions related to that. One of the issues, at least in Los Angeles, is that the just cause ordinance, and I'm pretty sure in the north, in the Bay Area, they have something similar. So a lot of times somebody has a house and they go, okay, as part of the estate, we want to sell it, but there's a just cause ordinance. So just because you're selling the estate to some, third party doesn't mean you can evict the tenant that's living there. And that's kind of like independent of anything else. Do you guys have that in the Bay Area?
Absolutely. Yes. We have it in San Francisco, Oakland, Berkeley, Richmond, all kinds of cities. And Michael, I'm so glad you pointed that out because on top of the city and counties that you have to watch for, we have AB 1482, which is California's statewide rent and eviction control. So a whole other layer that we have to focus on as well.
Yeah. And just one last thing, before we started today's webinar, I had a eviction demur in Los Angeles eviction court, and I'm representing the tenant. And I had some really technical arguments, and the judge went along with them. I was like, I was surprised because sometimes these judges are like, yeah, so who cares, you know? But this time he he sustained them. I was very happy. So technical arguments work. There's a lot of law that says, you know, because of the drastic nature of the remedy of kicking someone out of their home, you know, this is why these judges, if they want to, there's a lot of judicial discretion. They can be nitpicky and technical or say, I don't care.
Well, we're going to get a little more into that with one of our next cases. So I am going to move us along. While I'm doing this, Brooke, if you're paying attention, we had a question from Lynn, which is, when can we register for this great conference that Anna, who's part of a whole team, is putting together? And I'm guessing the registration link probably won't go up until next year, but I could be totally wrong. And so if Anna has information about that or Brooke has information of that, please put it into the Q&A tab and we'll get that. So let's move on. Simwellian versus Life Generation Healthcare. And so an interesting case here because it involved an arbitration. The arbitration was appealed. The court actually addressed the substantive issue, which you don't see a lot of in arbitrations. And the reason that the appellate court was able to address the substantive issue is because the arbitration agreement provided that the arbitrator cannot commit an error of law. But so just real briefly, what happens here, we have a co-founder of basically nursing and healthcare facilities. The co-founder, there's actually a couple of them, agreed to a partial buyout of their interest. So they retained almost a quarter of an interest in the company, but sold the rest of their interest as part of the operating agreement for the entity that was owning and operating the facilities. It prohibited any unit holder from engaging in a competing business with them, which is Life, and required all opportunities in the field to be turned over to Life. Well, lo and behold, you know, Life Generation discovered that the Simwellians were really violating those terms, sent out, you know, a notice to them that they were a breaching party, sent them notice, and sent them checks. So under the agreement, they had basically had the right to buy them out, sent them, you know, checks for $19.5 million. Nice little payout for violating your agreement. The Somalians said, no, you know, we're going to arbitrate. We're saying that non-compete clause was void. And the arbitrator looked at the Business and Professions Code and said, well, under the rules here, as long as there's not an exception to the rule on the sale of a business, that you apply the per se test, which is when you're dealing with this, that a violation basically is automatically void. It's per se void. And the arbitrator said, no, we're going to rule for the Simwellians and awarded them $21.1 million. So, you know, got an extra, you know, $2 million. Hopefully it didn't cost them an extra, you know, $2 million in fees to bring their arbitration case. When they filed to, oops, sorry about that. When they, here we go. Went back too far. Sorry about that. Here we go. They filed to confirm the award, and the defendants filed to vacate the award because the arbitrator under the agreement did not have the power to commit errors of law or legal reasoning. So that gave the courts the right to jump in and address the substance, as opposed to whether there was just some kind of process problem with the arbitration. Trial judge confirmed the award. The appellate judge said, that per se standard does not really apply in the facts of this case. It was really a case of first impression. What do you do when you're dealing with a partial interest where the unit holder retains an interest in the entity? And the court said, that's drastically different from the sale of an entire interest. Therefore, the rule of law that should have been applied was the rule of reason, where basically you look at, is the activity more harmful to competition than it is helpful? And Mike, I don't have it written down here. Do you remember, did they send it back to arbitration for that analysis of whether it's more harmful or helpful? Do you remember that aspect of this?
Well, I think it had to be, but just to interrupt, one thing about this opinion, I don't recall like specific facts. Like, did this person that sold his partial interest open up a directly competing company, or is this done in prospective of opening up another competing company?
Yeah, Michael, I recall the opinion was a little bit vague on what the violation was, but there really did not seem to be a contest as to whether there was a violation, right? They were just saying, even if there was a violation, it doesn't matter. The restriction was void.
Yeah. Well, you know what I noticed is one of my best friend's first cousin was for the appellant in this case. I could call him up.
Okay, so you'll give us an update in November. I want to get to our next case because, again, this is one where the two of you have expertise, and I always welcome having some kind of expertise. So here we go. The city and county of San Francisco, the kind of joint entity, passed an ordinance that stated that just cause reasons for evictions under San Francisco law would not apply. So basically, you could not proceed with an eviction under just cause unless the tenant had first been given a 10-day opportunity to cure before starting the eviction process. Well, the apartment association immediately challenged that and said that it is in conflict with and preempted by state law that only mandates a 3-day notice to pay or quit, if you're talking about rent, before eviction proceedings. The trial court said, well, the ordinance violated the state rule regarding payment of rent, but not other grounds for eviction, where you could also give, a 3-day notice to cure or quit. Both parties appealed. The appellate court looked at the California Constitution to figure out, how do we determine if preemption is relevant, right? And what are the rules, right? And ultimately the court said, you know what, the 10-day notice for both rent and other defaults are preempted and invalid. I'm just going to quickly go to the next slide. So San Francisco, a writ was issued saying you cannot enforce that ordinance. And there was a couple of quotes that I took from the case. One, which was really citing to a statement by a San Francisco supervisor that basically just said, 3 days is unfair. We don't like 3 days. It's unfair. If you look at other areas of the law, nobody loses their property or their home in just 3 days. And we don't like it. We don't think we think it's unfair. We think at least 10 days is a little more reasonable, because people inadvertently forget to pay their rent all the time. And 3 days is not enough time for somebody who just made a mistake, and just forgot, oh yes, my rent is due on the 1st or the 3rd or the 5th or the 15th of the month. Just forgot all about it. And we don't want to punish those people. And therefore they need at least 10 days to make up for that. And then the court said, basically in the preemption portion of the opinion that said, you know what, this 3 days is not an anomaly in state law. Look at all of these other statutes that provide timeframes in landlord-tenant relationships. So there's an all-encompassing purpose to these state laws. So I thought both of those were interesting. Enough of me. Michael, Anna, what do you have to say?
Well, I'm gonna let Anna go with this, but this goes back to a very famous case in a landlord-tenant law called Birkenfeld about the difference between substantive changes, procedural changes, preemption, notice, both notice before you can do an eviction, like a 3-day notice, say, and then a notice before you can give a 3-day notice. These are all these issues that have been repeatedly coming up over the last, I guess, couple of decades. But
Yeah, I absolutely agree. Birkenfeld is such a key case in this arena. You got to read it if you haven't, if you practice in this area or are just interested. I can touch very briefly on the practical implications of this case because I dealt with it for the last couple years. So really what happened is anytime as a landlord, you or a property manager, you need to serve a 3-day notice to pay rent, to cure a lease violation, or to address a nuisance problem or illegal activity. Those are all 3-day notices under CCP 1161. And so what happened here is the city of San Francisco said, hey, hold up, before you serve your 3-day notice, you landlord have to serve a 10-day warning notice. And the city put out a form on its rent board website in some different languages, including English, that landlords had to use or substantially model their templates after. And what happened was it created a lot of confusion because what happens when you serve your 10-day warning notice and then the tenant, let's say it's to cure a lease violation or to stop being a nuisance or causing damage to the property. So let's say the tenant is a model tenant and wonderful behavior for that 10-day period. Then what? What happens after day 10? Can you not serve your 3-day notice? Or what happens if on day 11, then the tenant flips back and starts having that behavior that you needed to serve the warning notice for in the first place? So now, can you serve your 3-day notice? Do you have to give another 10-day warning notice? The statute or ordinance, it created a lot of questions that were unanswered like that. So we were, as our law firm was doing, we were serving our 10-day warning notices. We were guiding our clients throughout this process, but it created a lot of confusion. So last month in September, when this case came down, we stopped serving 10-day notices as a result of this case and flipped back to our 3 days. But the practical implications of these ordinances sometimes maybe well-intended by this particular supervisor, which Neil quoted, and I do find that quote very interesting as well. So they're trying to give people more time, but the appellate court found that there was a clear preemption under state law. And the fact that the Board of Supervisors here in San Francisco tried to give tenants more time, it did create a lot of issues like the ones I just mentioned.
So we had some nice comments here. First of all, for the getting away from the case just for a moment, about registration for the March conference. If you look in the chat, you will find something posted by Brooke, our coordinator, and that we expect to have a registration link, I assume on the CLA Real Property section website in the next couple of months. So we still have plenty of time, so it's something to look for. Going back to the case, or going back to the previous case, Glenn said, so in terminating an employee, does the per se standard apply? I think it would, which is my reading of the prior case. Now getting back to the current case, Glenn says, well, yeah, 3 days may be kind of strict, but it is offset by what we are learning about in the earlier case before the interview, which is there's strict compliance, right? So 3 days may be tough to comply with, but on the landlord side, unless you do everything exactly right, you're not going to be able to take advantage of that 3 days. So that's kind of a trade-off there. And
And Neil, just so you
yeah,
know, it's not 3 calendar days. Now it's, you don't count weekends and, legal holidays. So often there's more than 3 days.
yeah. Good,
Exactly.
good point, Michael. Thank you. Thank you. So just a lot of stuff going on, right? Glenn points out, well, if every county did what San Francisco did, then there really wouldn't be a statewide rule. Well, that's kind of the whole issue that gets involved with preemption. So we just have a few minutes left. So let's just go on to our announcements briefly in the few minutes that we have left. Once again, we always want you to get involved. People think, I can't put on a webinar. Yes, you can. Anybody can put on a webinar. You're bound to have some knowledge in some area of law that affects real estate practitioners. You could do it. Guess what? If any of our listeners are in San Diego, tonight is the Funky Fall Soiree. And I remember going to that before the pandemic, and it was a lot of fun. I'm so glad to see they're bringing it back. There's a band, there's great networking opportunities. It's for more than lawyers in San Diego. So there's a lot of um, industry related people who attend the fall soiree. And it's just a good feeling for a few hours. So if you get a chance, oh, thank you. Brooke just posted in the chat the link to the Funky Fall Soiree. So if you're looking for something to do tonight, you want to have some fun, you want to meet some real property practitioners or some, related people that maybe you could get business from, go and have some fun. Next month, November 13th, Anna's going to have that great webinar with the assistance of somebody from one of the other sections. And the link is not available yet. We expect that link to be posted in the next few days. So be on the lookout for that. I actually have a webinar in December on broker compensation, and there was this big class action ending our settlement, which is now in effect. So I'm going to be talking about that with a couple of other lawyers. Get involved, get involved, get involved. Next month, we've got some cases on hand, unless something better comes along. So CEQA exemption, kind of narrow. COVID vaccination orders, right? We thought we were through with that stuff, but the court basically said in this case, you know what? It's not moot because who knows what's going to come next. And then I thought there was an interesting bankruptcy case, but we're going to be paying attention to cases before then, because if we have some better stuff, we'll do the better stuff. And next month is going to start the Simkin secrets. So, you want to come back and join us for that. Absolutely. I'm through talking. Michael, I'm going to let you make some closing statements, but before you do, Anna, thank you so much for joining us today. And if you have something you want to say to our audience, please do.
Thank you for having me. It was a lot of fun. Your What's Up With Us program is incredible each month. It's entertaining, it's fun. The cases are interesting to read about and have on our radar. So thank you both for doing this every month. It's a great program.
And you gave some great practical insight, especially for that last San Francisco case. So thank you. Michael.
Well, thank you, Anna. And for the people that have joined us, if you happen to have some case that you think is interesting, and like Neil mentioned, we discuss interesting cases, okay? It could be about bird scooters that are left and people trip over it, this COVID thing, whatever. But if you know of some interesting appellate case, we'd love to, go over it and discuss it here. Or you can join us even as a guest. Maybe you guys have some interesting case that's going on. And as far as the funky, soiree happening, anybody can go to it. But if you join the real property section, then you're going to get email reminders of all these fun events, so you can join us. So thank you.
Sounds great. We're at 1 o'clock. Thank you. Join us next month. You see on the screen, you got my address, you have Michael's address. Thank you for the suggestion about that foreclosure statute that's going to take effect I believe that one takes effect January of next year. There were some of them that had a delayed effective date. I'll double check on that before next month. And again, any ideas, any suggestions, we are open. Pay attention to your email. I think tomorrow you'll get a copy of the presentation and you'll get your 1-hour MCLE certificate. Until next month, bye everybody. Thank you.
Thank you. Bye.